The Ohio Mock Trial Program is a statewide educational competition designed to educate students regarding the law and the Constitution, as well as build important critical thinking, public speaking, and interpretation skills. Each year, a committee of volunteer attorneys create an original case based upon a constitutional issue. During competition, each team will have the opportunity to argue their case as both the prosecution and the defense. Each trial consists of 4 main elements: opening statement, direct examination, cross-examination, and closing arguments. You'll see an example of each of these elements here today. In the case you'll be seeing today, Phillips High School agrees to license the naming rights to its field to a large multinational corporation. In response, students organize protests, post flyers, and take actions both in the school and near the field. In response to this, Phillips High School installs additional security cameras, searches student lockers, and files an action to remove the students from the field. The students counterclaim, asserting that the school district has violated their First and Fourth Amendment rights. The first trial element you'll see today is opening statement.
The opening statement is the first thing that a judge is going to hear in the trial. So it's very important that the attorney engages their audience and also establishes the major theories they have for the case. They should start off with a theme, a 1 or 2 sentence explanation of what they think the case is about. They should also give the court a version of the facts of the case that is favorable to them. Finally, it's very important that the attorney establishes what they have to prove in the trial in order to win, and the major evidence they intend to provide to do so.
May it please the court. Your Honors, the peaceful learning environment at Phillips High School has been disrupted. When that process is disrupted, it is vital that the learning environment of the school is restored.
The direct examination is the portion of the trial where attorneys question witnesses who are friendly to their side of the case. The attorney should ask open-ended questions and should be genuinely engaged in what the witness has to say. The witness should really be the star of the direct examination. They should understand the facts of the case and lay them out in a way that is friendly to their side of the trial. Objections can be made anytime an attorney believes that a question or testimony violates one of the Ohio Mock Trial Simplified Rules of Evidence. When an attorney wants to make an objection, they should stand, say objection, and then state the grounds for their objection. Then if the judge wishes, they can allow the other side to respond as well.
The defense calls Jesse Springfield to the stand. Could you please introduce yourself to the court?
My name is Jessie Springfield. I'm 17 and I'm a junior at Phillips High School.
Why are you here today?
I'm representing 5 of the members of Occupy whose voices are being silenced by the school.
Finally, was Occupy disruptive to education at Phillips High School?
Objection and proper expert opinion.
May I respond, Your Honor?
You may.
This question doesn't call for expert testimony. I'm simply asking the witness about her perceptions of education at Phillips High School.
Your Honor, may I respond?
You may.
Your Honor, this is asking for expert testimony because as to whether the education was actually disrupted, it goes to Tinker v. Des Moines.
Objection sustained.
Was your education disrupted by Occupy?
Not at all. If anything, it was the opposite. So much debate and discussion came up from this deal, and it was really exciting to actually take what we were learning in our class and apply it to our lives.
Cross-examination is the portion of the trial where attorneys question witnesses from the opposing side. The goal of cross-examination is to damage the opposing side's case and the witness's testimony. On cross, the attorney should be the star. They should ask closed-ended questions that ask for a yes or a no and prevent the witness from adding additional information. The witness should do their best to maintain their testimony from direct and maintain their case in general.
Let's talk about why you're here today. You and 4 other Occupy members' lockers were searched, correct?
That's correct.
And so were your backpacks, right?
Yes,
Now, you say this was without your consent, correct?
it was.
No further questions.
The closing argument is the last thing a judge will hear in a trial, so it's very important that the attorney ties all the elements of the case together. They should go back to their theme from their opening that they've threaded throughout the rest of the case, and they should also apply the facts of the case to the law so that they can prove to the judge that they deserve to win their case based on the merits that they have presented to the court.
May it please the court. This is a case about reasonable actions in unreasonable circumstances. The actions taken by the school were taken to preserve and protect the learning environment. Thank you.
Mock trial is an incredibly rewarding experience as an educator. It's amazing to see students grow in terms of their thinking, their public speaking skills, their writing skills, their reading skills, as well as the camaraderie that students get from the experience in becoming a team. But the most important part is that mock trial teaches students to believe in themselves, to believe in what they can do, and the skills they learn from mock trial will be useful to them no matter what they end up doing with their lives.